Caught you unawares, Mr. Callahan.
Sorry.
My Lord, if I can just pick up on a few of the points that were raised
Yes.
in the earlier session, just for your note, and we'll get you a copy of the provision. Working life is defined in paragraph 5.8 of Schedule 3 to the 1992 Act, and it says, the purpose of this Act, a person's working life is between the tax year in which they have attained the age of 16 and the tax year in which they attain pensionable age or died under that age. So it is 16.
Yeah.
To,
thank you. I think you say it's quoted by the judge, but we didn't actually have it. Yeah. Okay. Thank you. That's helpful.
My Lord, you asked about the three categories referred to in the government's response to consultation. There were 3 bullet points.
Yes.
And whether or not they would get credits.
Yes.
That's at page 201 of the supplementary bundle on the bullet points. And what I'm told, in respect to the first bullet point, those who had supported the home rather than being in paid employment, if they had a child, they would have received maternity allowance, and that would account for a credit. Credit. But if they didn't have children, then the answer, I think, is no. The second category, unable to work due to illness, disability, would be yes. And then third category, those who'd recently left full-time education, only if they were disabled at the time.
Yes, thank you.
Then, my Lord, you asked about do we suffer any prejudice if the a new status or new definition of status is provided there? But my instructions are, in a sense, yes, because it's a maybe, because we've not had time to think through all of the benefits that go back over the last 50 years to see what their conditions were and so forth.
Okay.
Obviously, as a point of principle, we're concerned about shifting sands within a judicial review.
That I do understand, of course, yes.
Which we appreciate. But we also think there may be some particular problems going back, even applying the test, because the benefits don't necessarily apply to those who are between the ages of 16 and 18.
Yes.
And therefore it wouldn't be within the working life definition.
Yeah.
There's also obviously a difficulty in that one may be creating an exemption which would be on its face discriminatory against people born abroad or who'd lived long periods of time abroad, because they wouldn't have been on those benefits for all their working life. Because they would have been in other countries, and that would be race or nationality discrimination, or indirectly. So, and one should always be careful when one is drafting exemption that you don't create more convention problems.
Thank you.
So, those are the ones that were raised during the earlier session. So, my Lord, I have therefore concluded my submissions on justification, save to say that based on what I've said, based on what I've submitted already, my submission is that Mr. Justice Kerr erred in his approach to Bright Line and in his overall approach to justification. I just want to point out one particular point that is made at paragraph 45. I think it's on page 92. No, sorry. Sorry, I'm looking at the wrong thing. Sorry, it's 9. I'm looking at 92.
Paragraph 92.
Paragraph 92 of the judgment of Mr. Justice Kerr, page 112. where he says that he only gains limited assistance from the Northern Ireland guidance, and had he upheld our arguments in favour of a simple bright line rule, we would follow the guidance is inappropriate. But if I consider O'Donnell is correct, the guidance still does not itself prove that the SOS's concerns about complexity, delay, and expense are wholly unfounded. Now, I read that as the judge accepting that there is a foundation to the concerns around complexity, delay, and expense in having something which is not the simplified condition requirement. And from that, we say he should have concluded that satisfied the manifestly without reasonable foundation test. Whereas in fact, he then goes on to say that's not enough weight to sustain the justification defence.
Yep.
The further ground of appeal with respect to Mr. Justice Carr's decision related to his comments around O'Donnell and whether or not and their application of the international conventions. And our submission is that those statements within O'Donnell were not merely obiter, but were part of the ratio of the case. And our submission is that Mr. Justice Carr erred in finding otherwise. We set that out in our skeleton argument between paragraphs 51 and 55. I'm not going to take you to that now because I appreciate the time limitations, but in particular...
Yeah, well, don't feel under time pressure if they're important, but if they think
my
you've
lord,
said all that needs to be said in the skeleton, fine.
Yeah, well, my lord, they're paragraphs 53 and 54 in particular. Because our submission is that, and Mr. Justice Carr accepted, that it's an error of law for a court, a domestic court, to make findings of a breach of findings that the UK government has breached international obligations where those obligations are not incorporated into domestic law. That's what Lord Reid has said in SC. And in the O'Donnell case, Lord Justice Stevens, speaking to the court, did find that there had been a breach of 2 international conventions. What Mr. Justice Carr went on to say was that was only obiter, it wasn't ratio in the case. Our submission, as set out 53 and 54, is it was ratio.
I don't know how central this is, but surely, am I missing something? It's entirely orthodox to say that it's an aid. Well, I'll start again. Perhaps this is the point. If there is reason to believe that a piece of legislation is designed to give effect to an international convention, it will be relevant to look at whether the extent to which it in fact does so, or whether it fails to accord with its requirements. What SC establishes is that outside those circumstances, a breach of unincorporated international law can't, well, it certainly obviously can't invalidate the requirements of a statute, of a domestic statute. And does it go so far as to say it's not even relevant in deciding a disputed point of construction?
Well, we're not dealing here with statutory construction. We're dealing here with...
No, I see, that's the point.
Convention.
Yep.
And Lord Reid in SC at paragraph 84, and this is at paragraph...
Which tab are we on?
Well, it's in paragraph 52 in my skeleton argument, if you could just take it from there.
Sorry, yes, I didn't really give this the focus because it didn't seem a central point. Otherwise, I would have reminded myself of exactly what was said. Which paragraph?
Page 35.
Yes,
Great.
page 55. our domestic courts cannot determine whether this country has violated its obligations under unincorporated international treaties. That's the statement.
Well,
as in, this is not a court to adjudicate on those matters. Our domestic courts shouldn't adjudicate these matters, and that is what Lord Justice Stevens did do in O'Donnell.
it's not so much that; it's the next point in 52. Domestic courts should not approach the question of justification with reference to the provisions of international treaties, or by deciding whether.
In a
yes, I see. I'm sure that's right. I mean, we'll say if it isn't.
Yeah. And our submission is that.
And I mean, Mr. Justice Kerr accepted that, but said it wasn't central to their reasoning.
He said it wasn't central. The reasoning of our submission is that it was.
So what follows from that?
Well, so we say there's another reason why Mr. Justice Kerr got it wrong, and therefore why this appeal should succeed. It also feeds into the analysis of O'Donnell and how you should approach O'Donnell, and so I should come to that now.
Yes, right.
And then I'll deal with the issue of remedy at the end.
There's a funny grey area though, isn't there, where the Strasbourg court has said, oh, these various international conventions are relevant to the scope of various convention rights, and
yes,
sometimes there's a bit of confusion between that reasoning and the point you're making now.
yes. So in a case like Demir and Turkey, which your Lordship may be familiar with, which is the right to strike type cases, right to strike case, they do take into account the decisions of the ILO, the International Labour Organization, when deciding upon the breadth of a convention article, their Article 9.
But I think, don't they in O'Donnell rely on something Lord Wilson said in the Supreme Court?
Yes.
About the convention being relevant to an allegation of breach. Well, I'm presuming you're going to come on to that.
So in terms of O'Donnell, we say the approach to adopt is that set out in Dean, which is that this court should give respect to the decision of a court of appeal in Northern Ireland. You're not bound to follow it, but they go on to say that a court, when dealing with a matter of statutory interpretation in the social security sphere, which applies both in Northern Ireland and in England and Wales, ought to follow it. But the language of ought is not mandatory. It's more of a suggestion rather than a requirement. It doesn't say you must follow it, you should follow it. It's ought to follow it.
Right. That's very.
Well, it's a rule of practice, not a rule of law, but it doesn't mean it lacks any force, as is clear from decisions we're talking about.
But one should depart from it. I mean, it can't be a lesser test, my submission, in terms of the Court of Appeal in Northern Ireland than it would be if you were considering the decision of this court, Court of Appeal of England and Wales, where there are reasons why you can depart from a previous decision under the Young and Bristol Aeroplane principles, where...
Or indeed, more to the point, but I think, I'm not sure it's even so, in Kadim, where simply a point wasn't argued or wasn't taken into account. Yes, but...
So it can't be less than that, and my submission is that it ought to be, or should be, more than that, because we're dealing with, we're not dealing with the Court of Appeal of England and Wales, we are dealing with the Court of Appeal in Northern Ireland. Now, you've asked me to, you've referred to the Abbott case, which is quoted.
Bring it with me, but
it is quoted in Dean.
It is,
and
but the bit that's quoted in Dean doesn't give you the full flavour you get by reading the report.
Yeah.
because, well, as I put to you, really what they did was they said in polite language the Court of Session was wrong, the Inner House was wrong. They expressed it in terms of doubts, but when you look at it, the actual reasoning, it's pretty explicit. They said, nevertheless, we'll follow it.
Yes. We've managed to obtain a copy, at least for me to read out, but in Lord Evershed's judgment,
yes,
I think it's 1960.
I didn't bring it in with me, but
but it's 1960 Chancery,
yeah,
27, and at page 49, he says, those two things the Scottish court has, I think, plainly decided. I ask myself, therefore, having expressed such doubts as I have with all respect to the judges in Scotland, ought this court now to answer those two questions in a precisely opposite sense? It's quite true.
Answer is no.
We're not bound to follow the decisions, but the Income Tax Act and the relevant Finance Acts apply indifferently both north and south of the border. And if we were to decide these questions in a sense diametrically opposed, we should lay down a law for England in respect to this not unimportant matter, which would be completely opposite to the law which applied north of the border. I cannot think that is right. In the case of a revenue statute of this kind, it's the duty of this court, unless there are compelling reasons to the contrary, to say, expressing such doubts as we feel we ought to do, that we should follow the Scottish decision.
Yes.
Now, but my lord, the difference between that case and this case is there you're dealing with the same piece of legislation, the Income Tax and the Finance Act, which did apply both in England and Wales and in Scotland. So they are interpreting exactly the same piece of legislation. Here, we are not dealing with the same legislation. Of course, they are remarkably similar, but we are dealing with primary legislation from Parliament, and we're dealing with devolved legislation in Northern Ireland. And although they are dealing with the same subject matter and the language is materially the same, and there is, so these are the points against me, and there is a general principle that they should try and ensure parity between the two systems, they are in fact different sources of legislation. And therefore there would be a reason to treat them differently. And so therefore you're not in exactly the same territory as in the Abbott and Philbin type situation. That's why I submit in Dean they took maybe a more
well, I think indeed they thought they were doing what the Abbott and Philbin had done, didn't they?
Well, they say again. They do say they ought. They do say they ought to follow it.
So the distinction that you're suggesting wasn't one that was adopted in Dean, which is a case about Northern Ireland.
But and I'm saying we should follow Dean, and the test is ought to follow, but one doesn't have to follow if there are good reasons not to.
Well, I think the formula is something like compelling reasons not to. But
that's no. In Abbott and Philbin,
yeah,
they say in the case of a revenue statute of this kind, it's the duty of this court, unless there are compelling reasons to the contrary, to say, expressing such doubts as we feel we ought to do, that we should follow the Scottish decision. So it's the duty of this court. Now,
but what we don't get from either of the cases is, or from Abbott and Philbin, is what might amount to compelling reasons. Although we can infer that the fact that you would have reached a different decision yourself, it does not amount to a compelling reason.
Yes. The whether or not the Court of Appeal actually made this equation, the reason why it felt free to depart from the Northern Ireland case there was conventional reasons that would have applied equally to applying to a Court of Appeal decision in this court, namely Obiter stroke Kadim.
Yes. Now, here I commit a further point which distinguishes the cases is we're dealing with interpretation of, but we're dealing with the convention challenge to legislation.
Certainly, one difference between the system in Northern Ireland and the system here is that, as I understand O'Donnell, the Northern Ireland Court of Appeal could not make a declaration of incompatibility.
Yeah.
Whereas the courts of England and Wales
can do,
for obvious reasons, because England and Wales, well, in the case of this legislation, you're dealing with primary legislation, whereas the Northern Ireland Court of Appeal is not dealing with primary legislation.
Yeah. So that's certainly correct in terms of remedy. But I also have made the point, I made the point below, is that the deference that you should be showing to Parliament is greater than the deference that then should be shown to the...
Well, that might be thought to be a separate point, potentially.
No, but it is a separate point, related. We're dealing with the issue, here we're dealing with a convention challenge.
No, I understand that.
As opposed to a statutory interpretation challenge. And when you're dealing with a convention challenge, it will turn on what is the justification that's provided and what's the intensity of review that should apply to the particular situation.
Oh, I see. All right.
And that is different from a pure matter of statutory interpretation, which is what they're dealing with in the.
Why is that a real difference? In both cases, the UK Parliament on the one hand and the Northern Ireland Assembly on the other are democratic bodies making primary legislation. I appreciate it's a rather special, it's not the same status as primary legislation for the purpose of the Human Rights Act, but in other respects it's primary legislation. It's not delegated legislation. It's made by the Northern Ireland Assembly under its delegated powers.
But within the scheme of the Human Rights Act, it's treated differently.
Well, I understand that, but that's not. I thought you were making a slightly different point, that a different justification test applies because it's the Northern Ireland Assembly rather than the UK Parliament, and that's a reason why we shouldn't feel bound. But or not bound is the wrong word, but bound in quotes, why we shouldn't apply Abbott and Philbin, put it that way. Yeah. And I'm not sure it's a real distinction. The fact the Human Rights Act makes a distinction from the point of view of the availability of remedies is neither here nor there.
It's not just about the availability of remedies, it's also, in a sense, the structure of the Human Rights Act is to treat primary legislation at a with more respect, let's put it that way, than secondary legislation.
Have we got the Human Rights Act here? The relevant provision inside.
Because another point that flows from that distinction is that the Court of Appeal in Northern Ireland, in O'Donnell, said that to the extent that the provision was incompatible with convention rights, they would just disapply it, which the courts of England and Wales could not do because it's primary legislation here. And that again flows from the structure of section. I remember the section 3 or section 4.
Section 3.
Yeah.
We've got that, my lord, behind tab 3.
Well, section. Sorry, just looking through the relevant provisions of the section of the Human Rights Act. Section 3 applies equally to primary legislation and subordinate legislation. Declaration of incompatibility is only true with primary legislation.
Yes.
Don't we also need section 6? We haven't got.
Don't have section 6.
Because that's presumably what excludes. And then primary legislation is defined in section 21 in terms which don't include legislation of the Northern Ireland Assembly. We haven't got the provisions relating. We haven't. striking down would apply to effectively Section 6, wouldn't it, which renders any act of the state unlawful if it doesn't comply with the convention, but presumably excludes primary legislation. Is that how it works?
Just bear with me 1 minute. Lord, I am in fact looking at Section 4, which
Yes.
does
Sorry, my bubble has collapsed, which is
dealing with
a moment while I reconstructed. Yes.
So it does the courts that can make declarations include the High Court or the Court of Appeal in Northern Ireland. So they must be able to make a declaration of incompatibility in respect of something that comes out of Northern Ireland.
But only if it's primary legislation.
Yeah.
Or,
Yeah, but I think, my lady, primary legislation is defined in section
That's what we were just looking at.
21.
yeah,
It means any public general idea.
yes, I don't think it includes.
Yeah, no, it doesn't. It's an order in.
So that would be the Northern Ireland courts making a declaration of incompatibility about UK legislation, and there is some UK legislation which applies in Northern Ireland.
That's right. So, so my submission is that within the Human Rights Act there is in a sense, a hierarchy of legislation, and what O'Donnell.
Yes, there is, but for a particular purpose, there's a hierarchy of legislation, namely the availability, or what you can strike down. See Section 6, which we haven't got, but is presumably presumably there's something in Section 6 saying you can't strike down primary legislation. That's why you need Section 4. Is that right?
Yeah. So Section 6.1 is unlawful.
Mr. Royston wants to tell us the answer.
Sorry. Yeah, it's unlawful for a public authority to act in a way which is incompatible with the convention right. Subsection 1 does not apply if, as a result of one or more provisions of primary legislation, the authority could not have acted differently.
Well, that's what I thought.
Yeah.
So you're right in one sense there's a hierarchy, but is there a hierarchy in it? And that may be relevant to the question of relief. But on the question of the respect to be paid to a legislative decision by a democratic assembly, I'm not sure it makes any difference.
Right.
That's the point I was trying to put to you earlier.
No, I appreciate that. My Lord, my submission is that there ought to be, on the basis that the Northern Ireland Assembly is itself a creature of a UK statute. So within the devolution framework, it is subordinate to Parliament, because Parliament creates the Northern Ireland Assembly, and Parliament can take it away.
But that's an interesting matter of constitutional history. But in terms of the democratic mandate, once something is within the purview of the Northern Ireland Assembly, seems to me that it would have just the same weight as a matter passed by the UK Parliament as a result of its democratic mandate.
My submission is that there's a hierarchy, because they can. Yes, it's not just a matter of constitutional history, my lord. It's a matter of constitutional law as to who has greater power. Because one would then say, what about a local authority decision? That's also a democratically accountable body, elected. One would give them lesser deference than one would give to a.
Well, I'm not sure.
But my lord, that's
anyway. All right, it's not worth spending more time on that. Yeah.
But the essential point here is that we're dealing with a convention challenge rather than a statutory interpretation, and the convention challenge does turn on what is the evidence and what are the arguments put before the court, and who then have to make a judgment on the basis of that in accordance with proper principles, and there may be completely different reasons why in Northern Ireland I'm not, as a matter of principle, the Northern Ireland Assembly may decide to introduce a welfare benefit for different reasons, or some different reasons for why the UK Parliament introduces the same benefit, even with the same wording, and therefore they may not decide it for all of the same reasons. They may have different ones.
Does that matter if we're looking at objective justification? You don't need to look at what their actual reasons were.
No, but I'm looking
basis
at
on which they seek to justify them.
Looking at the way they seek to justify it. So you may have, 3 or 4 reasons in the UK Parliament, and only 2 reasons in the Northern Ireland.
Well, that's what we don't know exactly what the arguments were that were run by Una McConnell, or put forward by Una McConnell in her evidence.
No, but what appears from the judgment is that it may well be that they didn't argue the bright line point that is being argued here. That because as I said, it doesn't feature at all, in the O'Donnell reasoning. I took you to paragraph 98. So either there's an error of law in that they didn't, which is how I put it earlier, but they just didn't address, because they don't address simplicity at all.
It's not enough that there's an error of law. That was as the House of Lords eventually found out in Abbott and Philbin, found there was an error of law in the Inner House's decision, but that wasn't good enough.
But when one is dealing with a convention challenge, which is ultimately going to lead to either a declaration of incompatibility or reading in language into a statute which Parliament clearly didn't envisage, and actually here we would say chose not to do, one would expect a different approach from the courts.
Yeah.
Because you're essentially, from a constitutional perspective, obviously the Human Rights Act gives you the power to do this, you are saying we disagree with Parliament. We're not saying this is what Parliament said, you're saying this is what they should have said. And that in itself, I submit, requires a different approach. So, my Lord, those are the points of principle on that. But of course, if I'm wrong on that and you go with your provisional view, which is that there are strongly arguable points against O'Donnell, that would lead to giving permission to appeal to the Supreme Court, because only they should decide that, then my submission is that there are strongly arguable points. And so that's my fallback position.
Yeah, if we were persuaded by your points, I suspect the way we would do it, if we were persuaded by your points but not persuaded we should depart from McDonnell, we would write a judgment or judgments that made it perfectly clear what we thought, but in careful language like that are used in Abbott and Philbin, and hand it all over to the Supreme Court to sort it out.
Yes. Yeah. So my Lord, that would be my fallback. That's my fallback.
That's your
position.
fallback, I understand.
And my submission is that, and I've made a number of points along the way, that the Court of Appeal in Northern Ireland in O'Donnell did err in law, and I've shown you what they've said at paragraph 98 in terms of the contributory principle, and my submission is that's an error of law. They've simply applied their own, in a sense, value judgment to something which I submit on its face is not manifestly without reasonable foundation. They do not deal at all with the point of simplicity. Assuming that the bright line argument was run, they just don't address it. But even if it wasn't run, they don't deal with it, even though in the previous paragraph they say that is one of the aims of the policy. They then, at paragraph 99, specifically make findings in respect of the international treaties and say there's been a violation by the UK government of those matters, which they ought not to have done. And then they also say, my Lord, at paragraph 93, decision, if I can just pull that up. Tab 50.
Yep.
Page 1516. They've said the respondent has not acknowledged the discriminatory effect and quite simply has put forward no reason for having countenanced the adverse treatment. They set out the factors relied on. It says there's no discussion prior to the 2015 Act of making an exception for those who could not work throughout their working life due to disabilities. Now, they have ignored the fact that, in fact, earlier in their judgment, they refer to the fact that this category was discussed, albeit alongside a number of other categories. And the fact that the matter has been raised, that this is a group where a concern has been expressed, and yet no solution to carve something out for them has been provided, is a consideration of how to deal with them. And yet they say that wasn't done, so they've actually erred there. If I can find the, there is a, I think it's
Paragraph 13.
It is paragraph 13.
Where they're discussing the evidence.
Yep. That's right. So they deal with the same evidence that I've put before you in respect of that. But they treat that, at paragraph 93, as if there has not been any consideration of the matter, which my submission is that's just simply wrong. And then they go on to say, there's been no after attempt at justifying why such an exception could not be made. Now, again, I don't know the precise way the arguments were put, but it would be surprising if it wasn't argued that even after the event, it was argued that the 3 points of the aims were the justification for the difference in for not treating this category differently. They say these factors explain the measure, but they do not provide justification for the discriminatory effect of the measure. But when one is dealing with discrimination, indirect discrimination, one is looking at the measure itself as part of, if not all of your analysis. You're certainly looking at the measure. And here, the measure of, and in particular the contributory principle, it's supposed to apply to everyone. So that the justification for the measure is one of the reasons why you're not making an exemption. They're not making an exemption because it undermines the principle. So, my Lord, my submission is that there are a number of ways in which this court erred. And the paragraph 99, which is where they deal with the international matters, as I said earlier, my submission is that's part of their reasoning. We also consider that the respondent has failed to comply with the positive obligation to make necessary distinctions. This failure is confirmed by the respondent's breach of its obligations to comply with the UNCRC and the UNCRPD, which informs interpretation of the ECHR.
This predated SC, didn't it?
It did predate SC.
Yeah.
So,
which was specifically about the UNC.
Well,
this bit of AESC was about the UNCRC.
It was about the UNCRC, and then it went on to discuss more general principles. So, my Lord, my submission is there are a number of reasons why O'Donnell got it wrong and why you should not follow it in any event. But if I'm wrong on that, either there aren't compelling grounds or whatever test you wish to apply, then there are at least strongly arguable points as to why they got it wrong. Well, finally, if I can just deal with remedy, our submission, it's a very simple submission, which is that what Mr. Justice Kerr ought to have done was to declare incompatibility rather than read in language into the statute, and the reason for that is reading in the language goes against the grain of the legislation. I set this out in the skeleton argument at paragraph 57.
So is one of the points you make about O'Donnell that their approach to Section 3 was also wrong?
Yes. Sorry. Yes. So that's my further point. Is the remedy that they the remedy that they provided, which is reading in language, was wrong. Albeit I appreciate they may not have much of a choice as to what they do if they can't declare incompatibility.
Well, wouldn't it follow they can just disapply it under Section 6?
Well, I think they say earlier in the judgment that they would disapply it.
Yep.
But that might not have got the claimant home. I haven't thought it through. I mean, it may not have.
It might. Yes, it's a better remedy from the claimant's point of view. Yes.
And they couldn't just disapply the
because if they disapply,
condition.
Yeah.
Because it would apply to everyone.
Didn't help.
No, but they would disapply it to the extent that it had a discriminatory impact.
Yeah. Well, in any event, my submission is they ought not to have read in the language into the statute because it goes against the grain of the legislation. And Mr. Justice Kerr, in our case, ought not to have done the same. He ought to have declared it an incompatibility, and then leave it to Parliament to decide how to address the matter. I say it goes against the grain of the legislation because the wording of the legislation couldn't be clearer, the parliamentary history couldn't be clearer, and Parliament expressly considered the extent to which an exception should be made for this group, or had the information available to it, and obviously chose not to do that. And the contributory condition is a fundamental part of the legislation. Yes, there are two very narrow exceptions, but they are exceptions where there is employment has at least started. So there has been the process of obtaining the condition requirement has commenced.
And it's not being finished, not being completed for reasons that have got nothing to do with the choice of the claimant's the wrong word, but the person who would otherwise have been entitled.
So in those circumstances, there's an error. Even if you're against me on all of the points on substance, and this is probably not an Abbott and Philbin point, because on remedy, it would be a matter for you to look at it afresh in any event, and especially where you have the power to declare incompatibility, which the Northern Ireland Court did not have.
Well, I'm not sure about that. I think it is part of the court's ratio that it was possible to construe Section 3, to construe Section 30 in line with what it held the requirements of the Convention were, or so as to avoid a breach of the Convention, in line with Section 3. To the extent that we are, in quotes, bound by McConnell, we're just as bound by that part of its finding as by anything else, I think.
So then my submission, my Lord, is that there were compelling reasons as to why they were wrong, and either on the first point you should reach your own conclusion, or it should form part of a decision to grant permission to the Supreme Court.
Thank you.
So, my Lord, unless there's anything else. I'm reminded by my learned junior that Lady Justice Laing referred to a reference in O'Donnell to a comment of observations of Lord Wilson, paragraph 73 of O'Donnell. It's page 1510. This is Lord Wilson's comments in DA and DS were, I believe, subject to some criticism in SC, or rather were seen as obiter in SC. Let me just find the reference in SC. I apologise. Yes, so paragraph 94 of SC, page 1397. This is within the discussion by Lord Reid of international obligations. Sets out the head note. 95 refers to Lord Wilson. Paragraph 96, Lord Reid, so having set out what Lord Wilson had said, says, given the cautious language used by Lord Wilson when discussing the significance of non-compliance with the UNCRC and the explicit basing of the decision on the government's belief about the beneficial effects of its policy and on the availability of discretionary payments, it does not appear to me that those remarks form part of the essential grounds of the decision. So, essentially, Lord Reid is saying that's obiter, but if it wasn't, it's wrong, and yet in O'Donnell they rely on those very statements. My Lord, unless I can assist you further, those are my submissions.
Thank you very much indeed, Mr. Sheldon. Yes, Mr.
My Lord, my Ladies, can I start by summarising the claimant's position? I'm going to refer to my client as the claimant, as he was the claimant below. First of all, in terms of how the senior courts in Great Britain should approach the Northern Ireland Court of Appeal decision in O'Donnell, it's plainly undesirable for Great Britain and Northern Ireland not to have parity in relation to social security payments, including BSP. And it's clearly undesirable for different parts of the United Kingdom to take a different approach to the scope of its citizens' human rights. The result, if the Secretary of State's argument is accepted in this appeal, will be that people in Northern Ireland have greater human rights than citizens in Great Britain, and that cannot be desirable or right. So in principle and in practice, it is desirable and right that the senior courts of Great Britain, including this court, should follow O'Donnell. Unless, as Abbott and Philbin puts it, there are compelling reasons not to do so. Secondly, in any event, I submit that the Northern Irish Court of Appeal decision in O'Donnell was correctly decided. And third, I submit that even if it wasn't, it's clear from the High Court judgment that Mr. Justice Kerr approached the legal issues afresh and independently of O'Donnell, and he reached the same conclusions. And I submit that there's no arguable error of law in any aspect of the High Court's decision which is under challenge today. Now, I acknowledge that the Court's provisional view about whether O'Donnell should be followed, but I'm going to attempt to persuade you that the Northern Irish Court of Appeal and O'Donnell and Mr Justice Kerr below got it right.
Well, yes, you need to, because
Yes.
Suppose we adhere to our provisional view, we would still, as I think I made clear, express our own view in
Yes.
appropriate language, and you would want us to do it in a way that was helpful to you rather than against you.
Well, indeed, and my client doesn't wish to go to the Supreme Court.
Quite.
The structure of my submissions this afternoon, and I'm afraid tomorrow morning, will be as follows. First of all, I'm going to make some introductory remarks about bereavement support payment and the contribution condition, which will pick up some of the points that have been raised today. Next, I'm going to make some introductory remarks about O'Donnell. Then I'm going to make some introductory remarks about the High Court decision in this case. And then I'm going to address each of the grounds of appeal in the order in which they appear in the party's skeleton arguments rather than the order in which Mr Sheldon has addressed you today. So can I start with comments on BSP and the contribution condition? I've got 7 headline points to make. First of all...
Sorry, now, you have the same problem as, or I have the same problem as with Mr Sheldon. When you say headline points, are you just going to make the points and then develop them all over again?
No, well, I'm going to make points which will feed into some of my later points on...
I see, that's fine. When you said headline points, the most annoying thing is to write them down and then be told, oh, well, don't worry, I'm coming back to them later.
No.
No, okay.
These are points that
Okay,
I invite this court to bear in mind
Okay, off you go.
when
7
it addresses
points.
the grounds of appeal. So first of all, the legislative history. It's common ground that BSP replaced 3 different types of bereavement benefit. And it's also common ground, and in fact you were taken by my learned friend to the government's consultation paper, that the government's primary aim in creating one form of bereavement benefit was to simplify bereavement benefits and simplify conditions of entitlement. And the primary way in which it did this was by replacing the myriad bereavement benefits which had existed, the 3 different kinds, with one benefit. And by replacing...
Don't worry.
You're picking me up on the word myriad.
I was, and I
myriad.
thought I got life is too short, but you picked yourself up on it.
I did.
Yes. Okay, keep going.
And it also achieved its simplification aim by replacing multiple payment structures with one payment mechanism. In other words, you get paid X amount if you've got children and you get paid X amount if you don't. And it achieved that aim by replacing multiple contribution conditions with one contribution condition. Now, that is clear from the consultation paper. You were taken to those pages in the supplementary bundle. For your record, again, their supplementary bundle, divider 6, pages 155, and you'll also see reference to the simplification aim at 160, 162, 164, and 166 to 167. Now, in my submission, the government achieved its simplification aim simply by enacting sections 30 and 31 of the Pensions Act 2014. Because as you'll have seen from looking at that legislation, there's only one form of bereavement benefit now. There's only one payment mechanism, and there's only one contribution condition set out in section 31. And nothing in this appeal, I submit, will have the purpose or effect of undermining that broad legislative structure. So in most cases, you're going to get someone who has paid contribution conditions during their working lifetime, and their spouse will be entitled to claim bereavement support payment as a result, provided they comply with the other conditions which are not in dispute in this case. The second point I wish to make about bereavement support payment and the contribution condition is an obvious one. It's common ground that the BSP provisions in Great Britain and Northern Ireland are materially identical. You've been taken to the Pensions Act of 2014, which is the Great British legislation. Can I take you briefly to the Northern Irish equivalent, which is in Authorities Bundle tab 12.
Sorry, can I just interrupt and ask a silly question? Does the legislation which applies in England and Wales also apply in Scotland, or is there separate legislation that applies to Scotland?
It does. It applies throughout Great Britain, including Scotland.
Okay, thank you. Because you keep referring to Great Britain, I just wanted to check that there was a reason for that.
Absolutely. I'm reminded by my learned junior that social security legislation always applies across the whole of Great Britain.
Right, I didn't know that, so that's why I said, this is probably a stupid question. Thank you.
Not at all. So Divider 12 contains the Northern Irish Pensions Act of 2015. And if you have a hard copy, you may wish to have a copy of the Pensions Act 2014 provision open at tab 7 and compare the two. But they are materially identical, save for references to Northern Ireland or Great Britain, as the case may be. So my learned friend has rightly said technically these are two different pieces of legislation, but they are in form and content identical.
Sorry to interrupt again, can I ask another question, please? Is social security a devolved matter in Scotland? Yes. Partly.
I'm told it's partly,
Right, thank you.
but it is a devolved matter in Northern Ireland.
Yeah, no, we are.
Yes.
I picked that up.
Now, it's also common ground, although the Secretary of State has not referred to it in its skeleton or oral submissions, that the fact that these two statutes are materially identical in relation to BSP was a deliberate policy choice. And it was a choice to ensure adherence to the parity principle, which applies in relation to social security provision in Great Britain and Northern Ireland. And obviously, as you know, this principle ensures that a person in Northern Ireland has the same benefit entitlements as his or her counterpart in Great Britain and vice versa. Now,
Sorry to interrupt again. So, strictly speaking, because social security is a devolved matter, could the Northern Ireland Assembly decide to have different provisions, or is it just a matter of practice because of the parity principle that in practice they don't?
It's more than practice, my lady. It's
Right.
a matter of legislation, which I'm going to take you to right now.
Laura, sorry, I
So
shouldn't
the
have
parity
interrupted.
principle is actually enshrined in legislation
Yeah,
and has been since the late 1940s. I'm going to take you to the current version of
Lovely.
that parity principle. It's in Authorities Bundle Divider 4 at page 27. Now, this is the Northern Ireland Act of 1998, and at section 87, it provides the Secretary of State and the Northern Ireland Minister having responsibility for social security shall from time to time consult one another with a view to securing that, to the extent agreed between them, the legislation to which this section applies provides single systems of social security, child support and pensions for the United Kingdom. And can I invite my lord and my ladies to also look at subparagraph 2. And then over the page, subparagraph 6 says this section applies to, and we look at page 29, letter Y, the Pensions Act 2014 and the Pensions Act Northern Ireland 2015. So this was an absolutely deliberate choice by Parliament to ensure that there was parity between...
But there isn't a hard-edged obligation imposed by 871 as I read it.
They
They've got to
can, in
consult
principle,
with a
decide
view to ensuring
not
blah,
to
blah, blah.
agree.
Yeah.
But here we can see that they have made an agreement expressly by reference to the Pensions Act 2014 and the Pensions Act Northern Ireland 2015 that there should be parity. It's 87, subsection 6, letter Y.
Well, hang on a minute. The obligation is imposed by 87.1, and the obligation is from time to time to consult one another with a view to securing that to
Yes.
the extent agreed with the legislation to which this section applies provides blah blah blah, and subsection 6 tells you what legislation the section applies to. So my point about section 87.1 is it's not a hard-edged obligation to achieve parity. It's an obligation to consult with a view to securing it.
Yes,
To the
I
extent
accept
that is agreed between them. So it will also depend on the extent of any agreement between them for the time being, won't it?
Yes, it will, but it's been found in O'Donnell that indeed these provisions were made in accordance with the principle of parity under this section.
Well,
no
they
doubt
may
they-
well have been.
Yes, but you've got a perfectly good point here. Just don't overstate it.
I accept my lady's point that this is not a hard-edged rule, but in practice, Northern Ireland and Great Britain have operated a single system of social security with some but very few exceptions since the 1940s.
Okay.
And there's a good reason to do so because, as I've stated, it could otherwise have the result that people in Northern Ireland have different human rights than persons in Great Britain and vice versa.
Different social security entitlements.
They would certainly have different social security entitlements as well.
But Section 87 isn't concerned with convention rights, it's concerned with social
No,
security entitlements.
that's right. But for the purposes of this case, my point goes no further than the facts of this case.
All right.
But it also applies to social security entitlements as well. There are very few exceptions where Northern Ireland and Great Britain have parted company in relation to social security. The third point I wish to make relates...
But there are some.
There are some, but very few.
All right.
Well, I suppose you've shown us the legislation is virtually identical, so
Yes.
you would say this is not one of them.
Exactly. The next point relates to the amounts payable for bereavement support payment and evidence of impact. It's common ground, as my learned friend mentioned this morning, that BSP is worth up to £4,300 where a surviving spouse has no children, and that's spread over 18 months. There's an initial lump sum payment and then regular monthly payments up to 18 months after the spouse dies. So £4,300 where a surviving spouse has no children, and up to £9,800 where there are children. Now this raises the question of what the impact would be if claimants falling into the O'Donnell or Jwanczuk class are or are not excluded from entitlement to BSP. We take first of all the impact on the government, and in particular the impact on government finances. It's important for the court to note that no evidence whatsoever has been advanced by the Secretary of State as to the likely number of people in the class which we've been debating today. I'm going to...
Sorry, what point is this going to? Is it just going to the point, the general point, no case is made that it would be unaffordable if the law were as you say it is, in which case fine, but we don't need to...
Well, it's a point that goes to justification, my
But,
lord.
but
you're
is
certainly right, no argument has been made that this
well then
would be
why does it go to
unaffordable.
justification? The burden is on the Secretary of State to identify
Yes.
justification, and if they're not advancing a financial reason, you don't need to jump up and down on the point.
That's true, and certainly no financial reason has been advanced. They've relied more on administrative difficulty. But of course it does relate to that point, because if you're only talking about a very small class of person, then you're not talking about much administrative difficulty. So it does relate to justification.
I
in
see,
that
so
respect.
I've got confused. I thought it was a point about money. you started by saying it's common ground and you gave us the amounts.
Yes, and
You
then I'm looking at evidence of impact. So I'm first going to look at it from the perspective of the government. Is the government saying that this was totally unaffordable and we're talking about administrative difficulty on a vast scale because there are so many people involved?
I'm sorry, I'm just trying to think about this clearly. The money point isn't really what matters. The point is the numbers may be quite small.
Yes.
Yes, I see. Numbers of people, we just don't know.
We don't know. No evidence has been advanced on the point. So we don't know whether, when we consider administrative difficulty, we're talking about thousands of claimants, or hundreds, or even dozens. And I make another point, the fact that the Secretary...
Okay, I take your point, but it must be a substantial number, because where you have two married people below pensionable age and one of them dies, and they're both working, that must be a very common situation.
Of course, but I'm not talking about that class of person. I'm talking about the class of person that falls within the O'Donnell class. In other words, a surviving spouse of someone who has died, who was so severely disabled that they were unable to work.
Yes, I see. I was being slow. Yes, okay.
That's the point, that we have no evidence as to who falls within the affected class with which this case is concerned. So when the Secretary of State says what we're looking at here is significant administrative difficulty, they've advanced no evidence as to how many people are going to be affected. But the fact that the Secretary of State's advanced no evidence on quantum also strongly suggests that the impact on this class of person wasn't considered when passing the Pensions Act in 2014. And that does relate to justification. And indeed to the evidence given in this case.
Well, hang on. I just want to follow this through. I mean,
if I put it another
then
way,
you may have a separate point that it wasn't considered.
Yes.
You'll have to make that good in view of the material we've seen.
yes.
But the fact that we haven't been given any evidence as to the numbers doesn't really advance that argument at all, does it? You've got a fair point that we don't know what the numbers are, full stop. But it doesn't help us decide whether or not the government thought about it at the time.
Well, one of the ways in which they could show they had thought about it would be in an impact assessment, and we've all seen examples of government impact assessments, where they say this is going to cost the Exchequer £9 billion if we make an exclusion or an exception for this category of person.
Well, it might be said they didn't do that exercise because the main justification that was being advanced at the time was the importance of the contribution condition.
They may. I mean, it's not.
Well, again,
it's not a point that gets me.
These
home.
are very marginal points, aren't they, Ms. Callahan? I take your point, and I've written it down. We don't know what the numbers are.
No.
They may be small. But then to refine that into that's a reason why we might suspect they didn't even think about the point. We'll look at the evidence about whether they think
Yes, and I'm coming to that.
Yeah,
but
okay.
It's simply one of the points that goes into the mix on the issue of consideration. I've looked at the issue of impact from the government's perspective. From the claimant's perspective, in this class alone, in other words, surviving spouses of persons who are unable to work because of disability, there can be no doubt as to the impact of having been excluded from BSP on the claimant in this case, Mr. Jwanczuk, because Mr. Justice Kerr found as a fact in paragraph 15 of his judgment that Mr. Jwanczuk experienced significant financial difficulties after his wife's death. He not only lost his income as her carer and the income from the benefits she had been receiving, but he also gave evidence, which is unchallenged, that after his wife's death, in the absence of BSP, he had to rely on charity for essentials such as food and energy costs, and even to pay for his wife's funeral. The reference there is to his first witness statement, paragraphs 43 to 46, which can be found in the core bundle at divider 5, pages 34 and 35. So in other words, while the sum of £4,300, which we are arguing about today, may seem like a small amount to some, it would have made an enormous difference to him, and being excluded from entitlement to that sum has had a seriously adverse effect on him. And it's also important to bear in mind the difficulties that couples like Mr. and Mrs. Jwanczuk will already have experienced at the point at which a BSP claim is made. There is undisputed evidence in this case, which is summarised by Mr. Justice Kerr at paragraphs 3 to 6, that Susie Jwanczuk suffered from a form of congenital muscular dystrophy from birth. She had various health problems resulting from her condition, including dislocated hips, scoliosis, double curvature of the spine, respiratory failure requiring ventilation for the last 17 years of her life, diabetes, skin conditions, and clinical depression. Daniel was her primary carer throughout her adult years, and that is what they had to deal with until she died aged 45. Now, why am I mentioning that? Because, of course, I accept it's not this court's role to decide whether or not Susie Jwanczuk was unable to work. I mention it because there's good reason to think that Mr. Jwanczuk's experience is typical for other surviving spouses of people with a lifelong inability to work because of disability. Those surviving spouses are more likely to be on a low income because they lack the advantage of having had a partner who earned, and their own earning capacity is likely to have been affected by caring responsibilities, looking after their disabled spouse. And so entitlement to BSP is likely to make a particularly significant difference to those surviving spouses' ability to meet their bereavement-related needs. The fourth point I wish to make relates to the contribution condition. And for this, can we just go back to the Pensions Act 2014, Section 31. You've already been taken to it. As you know, all it requires is that for one tax year during the deceased's working life, he or she paid Class 1 or Class 2 national insurance contributions, and those contributions gave rise to an earnings factor equal to or greater than 25 times the lower earning limit. And as Mr. Sheldon has explained, the lower earnings limit for the relevant tax year was 123. It's barely risen since. And it becomes clear how easy it is to satisfy that condition. As Mr. Sheldon has conceded, a person could satisfy it by earning only £3,075 in one tax year of their entire working life. Putting it another way, all they would have to do is to work for 2 months full-time on the minimum wage at any point over the whole of their working lifetime. And it's important to appreciate how government itself regarded this contribution condition when passing the legislation. Can I invite the court, please, to turn to the supplementary bundle at divider 6, and it's page 273. This is an extract.
So we don't have divider 6. What page?
Well, it starts at page 272. It's an extract from Hansard, my lord. And Steve Webb, who was the minister responsible for the passage of that legislation, starts speaking at the bottom of page 272, and over the page at 273, at the bottom of the first column, he describes the contribution condition for BSP. And what he says is, as I mentioned, subsection 1b says that to qualify for the benefit, etc., they need to do X, Y, Z. And then he says it is probably one of the most, if not the most, relaxed contribution requirements in the system. And that is specifically to ensure that we support as many people as possible. Bottom of the first column on page 273. One of the most relaxed, if not the most relaxed, contribution requirement. And this is the requirement that Mr. Sheldon describes as being fundamental to the legislation. And I'll come back to that.
What he may be saying is to ensure we support the most people, as many people as possible, consistently with this feature of the scheme, i.e. the contribution condition.
Yes, but I'm obviously going to make the argument under the justification heading, as indeed the Northern Ireland Court of Appeal did in O'Donnell, that this is an extremely modest contribution condition.
That almost cuts both ways, doesn't it? If it was so modest, and yet they insisted on having it in, it shows that they attached a real importance and principle to this being a contributory benefit. And the UK system has always made a very clear distinction between contributory benefits and non-contributory benefits. It's a fundamental feature of how we've approached Social Security for ever, since Lloyd George.
Yes, and that may have more weight, my lord, if the government had expressly considered the impact of excluding this particular class of people, which they didn't, and I'm going to come to that in a moment.
Well, that's a distinct point, but I was really just making, I think, probably unnecessarily the same point as my lady, that the fact that only a very small element of contribution is required isn't necessarily a point in your favour.
No, I accept that, but the Northern Irish Court of Appeal in O'Donnell and Mr Justice Kerr found that it was a point in my favour under justification, and I say there's no good reason to go behind that finding.
Yes.
Now, also on the point of the contribution condition, there have been a number of questions from the bench today about whether or not one's status could change over time in relation to being unable to work.
Oh, we're still on your fourth point, are we?
Yes, that's right. I'm squeezing it in here because I want to get it in early. And the point is this. That's not a correct assessment, because when deciding entitlement to BSP for this affected class, what would be required to happen is that the decision maker at the Department for Work and Pensions would have to make an assessment after the death of the claimant's spouse in relation to whether that deceased spouse was unable to work throughout their working life. In other words, they're making a past assessment. They're looking back in time. We are not dealing with a situation where it's impossible to make a decision because that status could change in the future. There may be periods of time when the claimant was unable to work, and other periods where they were able to work. But the answer in that case is simple. They wouldn't fall into the affected class and they wouldn't be entitled to the benefit. So the argument that somehow my client's case doesn't hold weight because status could change over time doesn't apply here.
Well, it might do, depending on the facts, and it might do in other cases, because there might have been a period when it was absolutely obvious that a person wasn't able to work, whereas, the last couple of years or so, not so obvious.
Well, in that case, they wouldn't be entitled to the benefit because they wouldn't fall within the class. We have defined the status as being the spouse, the surviving spouse, of a deceased person who was so severely disabled that they were unable to work throughout their entire working life. And
Yes,
if
I
that's
think
not
that
the case,
phrase, right, that working life, doesn't actually appear in your official formulation, but it's implicit.
it's implicit,
Yeah.
because
I understood.
it's are they unable to work due to disability? That can only be a reference to throughout their entire working life, and that's made clear in the order that Mr.
Yes,
Justice
exactly.
Kerr made.
Exactly.
So they're making a past assessment. If at any period of time that person was able to work, or they make a determination that the person was able to work, they wouldn't fall within the class that we are trying to protect. And it would be perfectly open for the Department of Work and Pensions to reject the claim in those circumstances. My fifth point relates to the express statutory exception and its implications. The court will have seen that there are two express statutory exceptions to the contribution condition in section 31, which provides that the contribution is to be treated as met if the deceased was an employed earner and died as a result of a personal injury of a certain prescribed kind, and that's a personal injury caused by an accident arising out of and in the course of his employment. And we can see that in the provisions that my friend handed up this morning in the 1992 Act. The other exception is that they have died of a disease of another prescribed kind, and that's a prescribed disease which is due to the nature of the employment. And what this express pair of statutory exceptions means is that it's possible to fall within one or both of those exceptions where the employed earner has commenced employment but has suffered an injury or acquired a disease, asbestosis, etc., on his or her first day of employment. And so they had not yet actually paid any national insurance contributions or carried out more than a de minimis amount of work. And in my submission, there's a number of implications that arise from those express statutory exceptions. First of all, they demonstrate in my submission that the requirement to actually pay national insurance contributions is not a fundamental part of the legislation, because Parliament accepted that there would be cases where a person could be entitled to BSP even where their deceased spouse had not actually paid any contributions. If it would help, my lady, you're looking concerned, we can look at the wording of those statutory exceptions.
Oh, I mean, I understand the point you're making.
It's page 45. The contribution condition is to be treated as met. In other words, treated as though someone has paid national insurance contributions, even though they haven't, and they died as a result of a personal injury or a disease of a prescribed kind. That must mean that it's not a fundamental part of the legislation to actually pay national insurance contributions, because two exceptions have been made to that.
Well, that's obvious. I mean,
Well, if it's obvious, I'll move on.
no, I mean, I was interested in the points you were making based on it, but it's obvious that this is an exception to the obligation to make actual payments.
Yes, this is.
But it's a very narrow exception on your argument, because you say this would happen where they died or got ill on the first day of employment.
Well, it could arise in that situation, but it need not arise in that situation.
That's the only situation in which it will matter, perhaps not literally on the first day, but at a very early stage in their employment. Because otherwise they will have paid, very likely.
Yes.
They'll be able to satisfy the contribution
Indeed,
anyway.
They fall into the ordinary category.
Yes. So
it can only arise where they've literally not worked enough to have paid.
Yeah, a few
certain
weeks. I can't remember how the arithmetic works
level.
out, but a short time.
Yes.
Yeah.
So it's a very narrow exception, and it applies in cases where people had started work which would have enabled them to meet the contribution condition, but because of matters that were not their fault, they weren't able to.
I have to accept that, my lady.
Yeah. Okay.
But secondly, the second implication arising from these exceptions is that they demonstrate in my submission that Parliament was comfortable with accommodating the possibility that there may be occasional disputes of fact about whether someone had satisfied the contribution condition. Because, of course, there can be disputes of fact about whether the deceased died because of a work-related injury or disease. And I submit that the existence of these exceptions illustrates that Parliament wasn't seeking to impose a clear, bright-line rule, and that Parliament could deal with a certain level of administrative effort in having to reach a decision about entitlement to BSP.
Well, there's a clear rule, it's just that the application of the rule may involve fact-finding.
Yes, it will involve fact-finding. But I submit that the same applies to us. if the order made by Mr. Justice Kerr is followed, there will be a rule, and it will apply to a narrow category of person. And of course, there's an overlap between the category of person who falls within the statutory exception and our accepted class, which is that in both cases, it wasn't their fault that they weren't able to meet the contribution condition. One, because of lifelong disability that's so serious they were unable to work, and the other, because they acquired a personal injury or disease at the beginning of their employment. So we say there's an overlap there between the current case and those exceptions. The sixth point relates to government consideration of the excluded group during the passage of legislation. Now, in the Secretary of State's skeleton argument, and indeed today, the Secretary of State's placed great weight on the submission that during the consultation process that preceded the 2014 Act, the government was aware that the legislative provisions for BSP would exclude those who were unable to work due to illness or disability. And we've seen that my learned friend relied this morning on the consultation response document and a ministerial submission. Now, I accept that those documents say what they do about the fact that that category of person unable to work due to illness or disability was referred to in those documents. But I submit that that doesn't take the Secretary of State very far, because firstly, as the Northern Irish Court of Appeal observed in O'Donnell at paragraphs 12 and 93, the government gave no consideration to the impact of the contribution condition on that class.
But what consideration is required? I mean, if the contribution condition is applied to that class, they won't get the benefit, therefore they will suffer a financial loss that will equate at its greatest to the maximum amount of benefit to which they would otherwise have been entitled.
Well, that's true at one level, my lady, but of course, if the affected class is going to be disproportionately affected by the loss of this benefit.
So disproportionately compared by whom? Compared with whom?
Well,
The
compared
other
with
people
people
who-
who are not severely disabled and unable to work due to illness or disability.
Those are the people affected by it. I don't know what you mean by disproportionately.
Well,
I mean, obviously they will be affected compared with the people who get the benefit. That's my lady's point.
yes.
And that will have been obvious to the government. Oh, that's the whole point, is they won't get the money.
The point is, the government never thought about this category of person by itself and how this was going to impact on them by themselves, because they never considered whether or not an exception should be made for this group of people alone, as opposed to the wider group of people who were covered by national insurance credits. So in other words, what the government considered and rejected was a proposal that national insurance credits, given for any reason, should be included when considering entitlement. But if the contribution condition could be satisfied with national insurance credits, then 99% of potential claimants would meet the condition. That's what the government found. But the problem with this, which again is identified by the Northern Irish Court of Appeal and O'Donnell, is that the class of people who receive national insurance credits is much, much wider than just those who are unable to work due to disability, because it also covers people who are able to work but choose not to do so. Now, your lordship asked who is covered by national insurance credits, and in addition to the categories mentioned by my learned friend, they also cover, obviously, people who stay at home to raise children, but also people in training.
Hang on.
And I'll give the legislative references in a moment. So people who stay at home to raise children, people who are in training, people who are caring for disabled people, people in education, people who are unemployed, and the spouse of someone in the armed forces. That's regulations 7 through to 9F of the Social Security Credit Regulations. And if the court wishes, we can bring copies of those regulations to court tomorrow.
They're not one. We do have some.
You have some, but not
Okay.
all of them.
Well, we better have a complete set. Yeah.
Yes.
Thank you, Justine, just for completeness.
The point that the court made in O'Donnell is that grouping people who are unable to work through disability with that wider category of people means that the government only considered making an exception for people who included people completely different to the people in our category. In other words, the Secretary of State treated those who were unable to work due to disability in the same way as people who were relevantly different. In other words, people who were able to work but chose for whatever reason, be it training or caring for children, not to do so. Can I take the court, please, to O'Donnell on this paragraph? It's rather important in relation to the evidence that was advanced in O'Donnell, including Miss Una O'Connell's evidence. McConnell, I apologise. O'Connell, of course, is divider 50, and it starts at page 1485. Now, Una McConnell's evidence is summarised in paragraphs 10 through to 13. Those are the only paragraphs that refer to her evidence. And it's quite clear what her evidence was. In paragraph 10, she gives the history of the principle of parity.
Hang on 1 second.
And she mentions the provision I've taken the court to, section 87 of the NIA, the Northern Ireland Act. And she does say, my lady, at the bottom of page 1488, that parity is not inflexible and there is scope for the devolved government in Northern Ireland taking a divergent course. However, there are both practical issues and funding consequences, which she sets out across the page. And she herself says in paragraph 11 that the provisions in sections 29 and 30 of the Northern Irish Act ensure adherence to the parity principle. Is
that her speaking? I
It's
don't
the
know.
court, I think.
The court, surely.
Well, either way, I submit they're right.
Yeah, I don't think anyone's disputing it, are they?
And then they set out more of Ms. O'Connell's evidence in paragraph 12, which relates to the equality impact assessments in relation to the pensions bill. And then over the page at paragraph 13, it said that the affidavit of Ms. O'Connell also addressed the consultation process, the government's consideration of the consultation responses, and the policy of the government that entitlement to bereavement benefits is dependent upon actually having paid contributions. There's a long summary of her evidence there.
And sorry, that consultation would have related to the British legislation,
Yes,
wouldn't it?
exactly.
Is that right?
It does, yes.
Do we know that?
We do know that. In fact, it was
How do we
conceded
know?
by my learned friend in the court below. And that is why Mr. Justice Kerr made a finding of fact that the evidence in relation to what the government had done in this case and in O'Donnell's case was materially identical.
Yes, I see. So how does this work? I'm not doubting it. If you tell me it's common ground, I'm sure it's right. But does the Northern Ireland executive, which was presumably still functioning at this time, simply not carry out its own consultation and simply, as it were, borrow say this was all consulted about in the UK and in Great Britain, I should say, and therefore we borrow the result of that
Yes.
consultation.
Yes.
They don't do any. They're really, their policy analysis is parasitic on the British policy.
Yes, that's right.
Okay, fair
And in
enough.
fact, I took Mr. Justice Kerr in the High Court through all of the documents that are referred to in Una McConnell's evidence here, because they're also relied on in our case. They're
Fine.
exactly the same documents that you've got in the bundles here. and it was accepted by my learned friend that there's no difference in the consultation process or the consultation documents or what the government considered or didn't consider. And that is why Mr. Justice Carr made a finding of fact.
Yeah, I noticed that, but I didn't know how he got there, but you've explained that. That's very helpful.
And that's why it's wrong to say that we don't know what Una O'Connell said, because the material parts of her evidence are summarised in the judgment and are demonstrated by the documents which are identical to the ones in this case.
So we know the gist of what her evidence was.
You know the gist of what
we
her
don't
evidence
know
was.
the ipsism of her. But
You don't have a copy of the witness statement. But put it this way, when the argument was made in the court below, the Secretary of State had the opportunity to put in Ms. McConnell's witness
I see the
statement
point you're making.
and say the evidence is not the same, and they didn't take that opportunity. And the point is this: Ms. O'Connell makes clear, as we can see in the middle of paragraph 13, that if the contribution condition had also included credits, then 99% of potential claimants would meet that condition. However, then this is now the court's voice. However, in relation to 1, it can be seen that the respondent specifically recognised it would be excluding some 24% of potential claimants by not including credits. We can see that in the consultation documents and the ministerial submission. But then the court says it's also apparent that the cohort of 24% would consist both of those who were able to work but chose not to do so, and those who through disability were unable to work throughout their working life. In this way, it is suggested that the respondent, in deciding not to include credits, treated the severely disabled in exactly the same way as those without disabilities, which amounted to a failure to treat differently persons whose situations were significantly different. That's the thlomenos type of discrimination. In short, the severely disabled who couldn't work were equated to and parcelled with and treated in exactly the same way as those without disabilities who could work but chose not to do so. And those failings, if the court wishes to take a note of that, are evidenced in the government's consultation response document at Core Bundle pages 201 and 206, and also by looking at the multiple impact assessments carried out by the government, which are included in this bundle. In none of those documents do we see any consideration given to this class alone, separately from people who were relevantly different to them, or to the impact of only excluding this class. You will have seen, of course, Mr. Justice Carr's finding of fact that the evidence in the two cases is materially identical in relation to the government's evidence.
I wouldn't mind seeing the impact assessments. Where are they?
Yes, they're in Supplemental Bundle 2. Supplemental Bundle, Divider 6. And we can see in the index that they start at Exhibit HW9 and go through to HW10.
Yes, but I find it very uneasy, very difficult finding the various.
Yes, so the first impact assessment referred to is at page 211.
Perhaps I can just have another moan. People putting bundles together, if there's cross-reference to exhibits within a long thing like this, it's quite useful to have a reference for each exhibit. But anyway.
So page 211 is the first impact assessment, and one's almost looking for, one is looking for something that's not there, because there is no impact assessment focused just on the affected class of person in this case.
Sorry, I'm behind you.
Not at all. Supplemental Bundle, Divider 6, it's an exhibit to Helen Walker's witness statement, pages 211 all the way through to page 271. Those are all of the impact assessments that were conducted by government in relation to bereavement support payment. And in none of those
Yes, but there are different
pages,
sorts of impact assessments. Presumably what one would be looking for would be an Equality Act, the Section 149 impact assessment. Where's that?
well, these are them.
No, but the first one's a full economic assessment.
It's an economic
I
assessment.
mean, sorry, I haven't seen this material. You'll have to help me more. You say lots of assessments. I assumed they were different assessments for different purposes. Or is it one impact assessment with different bits?
It's one impact assessment is carried out in 2013, and it covers impact on individuals, for example, at page 218. Then we have the next impact assessment of 2014
Or where's that?
at page 2.
Why are there two ones in different years?
I can't answer that question. I'm not representing the Secretary
No, I
of
know,
State.
but you're familiar with this material. I'm not.
My Lord, it
I've
would
seen
be at different stages of the legislative process that one looks at matters.
Yes, I see.
Sometimes it's
Okay,
to do
thank
with
you.
amendments, sometimes it's different readings and so forth.
Okay, so
But-
let me just.
My Lord, put it this
Look,
way.
this may all turn out to be unnecessary, but if we're going to do it, we should do it properly. So there's an impact assessment from 2013, which I've got at 211.
Yes, impact,
There's an impact assessment of 2014.
2014, page 223.
Okay, hang on one second.
And nowhere in those two documents.
Wait, just one. Are there any other impact assessments?
Yes, there's another one, page 234, Pensions Act 2014 impact assessment. That's for the whole Act, I'm reminded, but it deals with bereavement benefit reform at page 248.
Now, are there any other? I just want to get the overview. Are there any other assessments?
No, not that
Right.
I'm aware of.
No,
that
okay.
have been
Well,
put before the court.
you will be aware of what there are because you've had a chance to read this. But okay, so we've got three assessments, and the first two are in similar format.
They are.
And how are they structured? They are. There's a section you showed us at 211 on 218 on impact on individuals, and is there an equivalent one in the 2014?
Yes, that's right, at page. Page 230.
Yes, I see.
And then
And is there a section anywhere which claims to be a section 149 assessment?
check that. But of course, if there isn't, then that demonstrates there was no consideration of the
Well,
impact on any of those
I'd be
groups.
very surprised if there wasn't, because although one may quite often have doubts about the quality of them, it's standard government procedure always to do an equality act impact procedure, isn't it?
Yes.
Can you help on this, Mr. Sheldon, just so that I...
Actually, I think I can assist. Pages 253 onwards contain a summary of impact of measures on key groups. And we see the impact on individuals and employers for different types of benefit, and the one relevant to BSP is at page 259. And again, the section on impact on individuals is pretty thin. It's page 259.
But I'm afraid you're not answering my question, and it looked as though Mr. Sheldon thought he was about to be able to. At least he got up.
I was about to speak. My Lord, as far as I'm aware, there was no bespoke equality impact assessment with respect.
Isn't that unusual?
My Lord, for this particular benefit, I think it is unusual, but I
There you are. Those are the facts. None was ever produced under your disclosure.
none that
You've
I'm
had that.
aware of.
So we've just got to make do with these, and well, then it becomes less surprising that what Mr. Halloran says, it doesn't really. You know, so you say if I read this, there's no point reading through it because it's attempting to prove a negative.
Indeed.
Yeah. Okay.
So the point
Thank
is
you.
made by both the Northern Irish Court of Appeal and by Mr. Justice Kerr in this case that no consideration was given by the government to this particular group and the impact on this particular group, or whether they should make an exception for only this particular group. We can see that at paragraph 93 of O'Donnell, which is back at 1516 of the authorities bundle.
Sorry, can I just ask, before we leave page 259, the heading says measure bereavement benefit reform, open bracket, see Annex D for further details. Have we got Annex D?
No, I don't think that has not been included in this bundle.
Do you know, are you able to say whether it was ever disclosed?
No, my lord, this bundle is a shorter version of the bundle that we had below because of the page limits. And I think there were...
Well, you can always exceed the page limit on application, but don't worry about that.
But the point is, if they were relevant, they would have been in this bundle.
Yes, no need to be confrontational about it. My lady just wants to know whether Annex D casts any light on the question that we're considering. Perhaps someone can check overnight.
I'll check. I don't think it does, because otherwise, as my lady
I'm sure.
would have been
I'm sure. Yes. Okay, thank you.
And both the Northern Irish Court of Appeal in O'Donnell and Mr Justice Kerr made a finding of fact, which I submit this court can't go behind, that these matters were not considered by government. So it's paragraph 93 of O'Donnell, and could I invite the court to read that? And there are various paragraphs.
I haven't finished reading, sorry.
Oh, I'm so sorry.
Yes.
And in the High Court's decision below, Mr Justice Kerr, at paragraphs 95 and 96, makes the point his decision means comity between the courts of the UK jurisdictions is preserved. I do not accept that the two cases have proceeded on different evidence. Now you know why.
Sorry, which paragraph?
95 and 96, my lord. I'm confident from a reading of O'Donnell and comparing it to the evidence of departmental and parliamentary procedure before me in this case, that O'Donnell and this case are being decided on materially the same evidence. The Secretary of State was in a position to demonstrate, if she could, that the evidence was different, but all indications are that it was not. It can be said with confidence that the facts are essentially on all fours in the two cases. In other words, there was not consideration given to this class of people. The seventh and final point in relation...
Hang on one second, I just want to make a note of that. It's not just no contemporary consideration, but no subsequent justification.
Correct. That's why it flows into justification. It's acknowledged that if a government has considered the point during the passage of the legislation, that it's more difficult to show that the measure is not justified. But where they haven't considered the point, then it's rather more difficult for them to justify excluding this category of people from entitlement to the benefit.
But it goes further than that, doesn't it? The first question, a very familiar one in this area, is where the legislator hasn't considered the point at the time, it becomes more difficult, but certainly not impossible, to justify it subsequently by reference to considerations that were not considered at the time.
Yes.
Lots of law about that, and
Yes.
we'll know where we are. But in O'Donnell, the court was making both that point and a separate point, which was in front of us, the court in O'Donnell. There hasn't been an attempt at ex post facto justification either.
Correct. All they've attempted to justify, the court says, is the aims of the measure. But what
they haven't attempted to justify the differential impact of which you were complaining.
Exactly.
Well, that's fine. I thought that was what you were intending to say. The way you put it just now, it suggested you were only making the first point, the point about more difficult in the absence of any contemporary justification. But if they don't attempt to justify it at all in court, then they lose simply because they haven't proved an issue on which the burden lies on them.
That's certainly...
and that's what they were saying in O'Donnell, wasn't it?
I think that is what they're saying in O'Donnell, my lord, because we can see that...
And they say at 94, that's sufficient to conclude the reference.
Yes.
Then they
and then they go on...
They go on just out of abundance of caution to ask the Bank-Mellat questions. But the structure of the reasoning is, we could stop here.
Yes.
Yeah.
What they make clear in this section of the judgment, really from 93 through to 100, is all that the Secretary of State has attempted to justify the aims of the measure, but they haven't been able to explain to us why it was justifiable to exclude this particular category of person from entitlement to BSP.
Well, if that's putting it slightly tendentiously, they would say that the aims of the measure include giving effect to the contribution principle, and if you haven't contributed, that's a justification.
Yes, but that's the
but
only
Mr. Sheldon says that they, in 93, don't seem to recognise that that's been advanced as a justification. They say you haven't advanced any justification. But he says we did.
Well,
namely, the contribution principle is a justification for excluding those who can't satisfy it.
but of course the court finds that that's not sufficient justification.
Well, does it? At 93 appears to be saying you haven't addressed the right question, rather than saying you have addressed the right question, but we don't regard the justification you've advanced as adequate.
But of course the court has found that the target that needs to be justified is the failure to treat differently people who are relevantly different.
Yes.
Because it's a Thlomenos type case.
Yes.
So that must
But
mean...
it's not as if no justification was advanced. The justification was the importance of the contribution principle. And maybe simplicity, but let's just take that.
Well, indeed. And in fact, those aims are summarised at
Yeah, but
paragraph
that's not just an
95.
aim. That it may be an aim, but it's also a potential justification.
Yes, and at 98 to 100, the court explains why that's not sufficient justification.
Well, maybe, all right, but I'm just trying to understand the structure of the court's reasoning. At 93, they do appear to say, we could stop here. And 94 onwards is just in case.
Yes, I mean, in 93, they spell it out. What must be justified is the difference in treatment. Or in this reference, the lack of a difference in treatment. In other words, the failure to make an exception or to differentiate between people who are in relevantly different positions, and not merely the underlying policy. Then they summarise all of the factors that have been relied on by the Secretary of State to justify. Of course, this is under the heading justification, so they're summarising the Secretary of State's case on justification, and the court goes on to say, but they do not justify the failure to treat the severely disabled differently from those without disabilities. And I say that that reasoning is impeccable. It's the failure to treat them differently that needs to be justified. So they're not ignoring the justifications put forward. They're just saying they're not sufficient.
Where were you reading from? Sorry.
Paragraph 93.
Yeah, okay. Well, we'll have to look at it carefully and see whether we agree with that.
But yes, I take your lordship's point that they do say it's sufficient to conclude the reference, But of course, for the benefit of the parties, they go on to apply the four-pronged bank mallet test and they arrive at the same result.
Yeah, right. Okay, thank you.
The final seventh point that I want to make about the BSP legislation is that there have been previous successful Article 14 challenges to BSP or to bereavement benefits more widely. And you were taken, well, one of them was referred to this morning by my learned friend. But I want the court to appreciate that, in fact, there have already been two successful challenges, one to the legislative provisions for BSP and one to its immediate predecessor, both of them in relation to a person's marital status. Could I take the court, please, to tab 39 of the authorities bundle, which I believe is in the second volume if you've got a hard copy. Yes, it is. This is a Supreme Court case of Henry McLaughlin. This is the case that my learned friend took you to this morning. And this case concerned the Northern Irish legislative provision which set out the conditions of entitlement to widowed parents' allowance. That's one of the three predecessors to BSP. And in this case, the Supreme Court decided that the legislative provision was incompatible with Article 14, read with Article 1, Protocol 1, and Article 8, in excluding from eligibility people who cohabited with the deceased person but were not married to them or in a civil partnership. My learned friend referred to the very useful history of bereavement benefits, which is summarised in paragraphs 4 to 12 of Baroness Hale's judgment. I don't need to take you to it. You've already seen paragraph 11. But it's important to note that in that case, the government also relied on administrative difficulties as a justification for not including cohabitees within BSP, or in that case, widowed parents' allowance. And what they said is, look, it's going to be very difficult and intrusive to have to find out if a couple are cohabiting, because we're going to have to ask the surviving spouse very intrusive personal questions about the nature of their relationship, including how often they had marital relations, did they live together, and so on and so forth. But in that case, the extra administrative work involved, which I say would be more significant than in this case, because there's no obvious documentary record or proxy for whether people are cohabiting, it's going to require a lot of individual questions by the decision maker of the claimant. Even that level of administrative work was not held to be sufficient to justify the discrimination. And we see that at paragraphs 87. This was Lord Hodge in the minority. Even Lord Hodge found that he didn't need to rely, and that these difficulties in administration, as there may be, can be a relevant consideration. But the majority, paragraph 53, this is the judgment of Lord Mance, said, I take the points made by Lord Hodge at 85 to 87. It's not always easy to judge how different benefits interact and how easy they may be to administer. But the position of couples who are neither married nor civil partners is already catered for in other situations known to the law. The starting point is surely that where children are for relevant purposes in a similar situation, the law would be expected to deal with them in the same way. I'm not persuaded that any substantial grounds exist, thinking that this was not and is not feasible, as well as just, in the present context. So the mere fact that it may be difficult to make a decision about who's a cohabiting couple and who's not was found not to be sufficient.
Well, why does it say where children are for relevant purposes in a similar situation?
Because the key reason the Supreme Court found that this policy was unjustified is that the children of cohabiting couples are in no different situation to the children of married couples, and so it's unfair to discriminate against cohabiting couples because it's the children
I see. Yes,
who
sorry.
benefit
No,
from
no,
this.
I see. I get the point.
Of course, the primary objective of the widow's parents, the widow's allowance, was to help the children.
Can I ask a nerdy question, please? I see they made a declaration of incompatibility in that case.
Yes, they did.
Was the Social Security Contributions Benefits (Open brackets Northern Ireland Act 1992) an act of the Parliament of the United Kingdom, or was it made under devolved powers?
I think it was the latter, and that is why they had to make a declaration instead of being able.
The former.
I think you mean the former.
Of course I do. I mean the former.
Yeah. Okay. I just wanted to check that.
But I'm sure that point can be checked. But that's my understanding. Is that's the reason. And
That's
that
why
It almost certainly is, because it wouldn't have Northern Ireland in the title if it wasn't
Exactly.
Yes,
act
indeed.
of the UK Parliament.
In fact, I think there's a reference in that case somewhere to only being able to make a Section 4 declaration. But I'm sure my learner junior, who was in fact in that case, will tell me if I'm wrong.
Yeah.
That's the
And
first.
while he's racking his brains, there seem to be as effectively two majority judgments which are presumably consistent: that of Lady Hale,
Yes.
and that of Lord Mance. Does Lady Hale deal with this point about?
No, she doesn't. She doesn't deal with administrative difficulties. But the
Okay.
implication of that is she didn't regard them.
Oh no, fine. I just wanted to know. Yep.
Yes. She didn't appear to regard the administrative difficulty argument as an insuperable obstacle.
Well, clearly she didn't, because she agreed with Lord Mance. I just
Indeed.
wondered whether she'd addressed it at all.
No.
Yep.
Those are the only two paragraphs, I believe, that address
Yeah,
that
that's
point.
very helpful. And what's the other case? Is
second-
Jackson.
It's Jackson and Simpson against Secretary of State for Work and Pensions, decided in 2020, and it's divider 44, just a few cases on. Now, in this case, Mr. Justice Holman was faced with the exact same issue, but this time in relation to the current legislative provision for BSP.
So the same issue as McLaughlin.
Exactly.
Yeah.
Same issue as McLaughlin, but this time in relation to BSP. And it may be relevant to point out that Baroness Hale had acknowledged that since the Pensions Act 2014 had come into force, but wasn't relevant in the McLaughlin case at the relevant time, and she declined to make any decision about whether the same result would be reached under the new Pensions Act of 2014. So, of course, that led to the secondary case here, Jackson and others against Secretary of State for Work and Pensions, where the same argument was run, but this time in relation to the current legislative provision for BSP. And Mr. Justice Holman held that the legislative provisions for BSP in the Pensions Act 2014 were incompatible with Article 14, read with A1P1 and Article 8, in excluding from entitlement cohabitees who were neither married nor in a civil partnership. It's relevant to note that in both cases the courts applied the test of manifestly without reasonable foundation, and they found that that test was satisfied. And again in this case, the government relied on administrative difficulties in trying to verify whether couples were cohabiting. That's paragraphs 53 to 55. Could I invite the court to read those paragraphs?
Yep.
So the court acknowledged there would be further administrative work required, but that any administrative challenges were insufficient to justify the discrimination. And my submission is it's going to be harder in a cohabiting couple's case to establish that they satisfy the eligibility condition than it is in this case relating to disability and inability to work as a result. So in my submission, there's already strong legal precedent for finding that the legislative provisions for BSP are incompatible with Article 14, at least in relation to marital status. Can I turn then to make some remarks about the case of O'Donnell? Short remarks about O'Donnell.
Yes.
And it may assist to go back to that decision.
We'll rise promptly at 4:15, but let's use the last
Yes, indeed.
5 minutes.
So that's
Yep.
divider 50, and it starts at page 1485. My short submissions are these. The Secretary of State sought to downplay the significance of this decision in O'Donnell and argued that it's wrongly decided. But first of all, it was the decision of a highly experienced panel comprising the then Lord Chief Justice of Northern Ireland, that's Lord Chief Justice Morgan, and a current Justice of the Supreme Court, that's Lord Justice Stevens, as he then was. Now, O'Donnell, this is just simply a matter of historical fact, O'Donnell was handed down on the 10th of August 2020, and Lord Justice Stevens was appointed to the Supreme Court a few months later. And notably, his lordship was a member of the court that decided the later case of SC, which sets out...
I have to say, this sort of point doesn't really...
Okay. Secondly, the judgment of the Northern Irish Court of Appeal on O'Donnell was unanimous. Thirdly, the issue in O'Donnell was identical to the issue raised in this case, and the arguments raised are materially similar. See paragraph 1 of O'Donnell, which sets out the issue. That is the same issue with which we are concerned in this case, but in relation to the Great British legislation. Fourth, there is much in the O'Donnell judgment with which the Secretary of State does not take issue. I think it's accepted, although it may not be, that the Northern Irish Court of Appeal carefully and correctly summarised the Secretary of State's evidence in paragraphs 7 to 17, and that includes Una O'Connell's evidence. The Northern Irish Court of Appeal then carefully considered the wording of the BSP provisions, see paragraphs 34 to 41. It's not disputed that this was a Flemenos type complaint, which the Northern Irish Court of Appeal assessed at paragraphs 42 through to 49. It appears to be accepted that the Court of Appeal correctly identified the questions applicable to an Article 14 discrimination claim based on Lady Hale's formulation in DA and DS, that's paragraphs 50 to 51. And there doesn't appear to be any challenge to the Court of Appeal's summary of the law in relation to each of those questions, which covers paragraphs 52 all the way through to 82. That's 30 paragraphs of analysis of the law. And the only aspects of O'Donnell with which the Secretary of State disagrees is the Court of Appeal's application to the facts when considering ambit, status and justification, and of course remedy. But my fifth point is it's notable that that decision in O'Donnell was not appealed either by the Department for Communities in Northern Ireland nor by the British government, which they would have been entitled to do because the Attorney General for England and Wales would have been notified of this decision and would have been entitled to be a party to the proceedings and to bring an appeal. But we understand, my Lord...
Well, I think if we hadn't participated in the proceedings, it would have been too late, wouldn't it?
No, because a party has the right to challenge an order in the case, and the Attorney General for England and Wales would surely be an interested party.
Well,
who would be
this is a very refined point of constitutional law. I'm slightly surprised at the suggestion the Attorney General of England and Wales would have had Lochrus to intervene in Northern Ireland, and I am slightly surprised to suggest that if they chose not to, that he could then have made a decision to appeal.
We of course will double check the position overnight. That's certainly my understanding, that they could have gone to
Well,
the
it's
Supreme
again,
Court.
frankly, it's a pretty marginal point
Well,
anyway. I mean,
it's
the
like
real
the
real
Auckland.
point is the Department for Communities should have gone to the Supreme Court, but no, it did or it didn't. I mean, it doesn't really help us. It didn't. Sorry, in the end, it didn't go. It didn't apply.
It didn't, and we understand there was not even an application for permission.
Yeah.
The sixth and final point is that following O'Donnell, the Northern Irish Department for Communities published guidance, to which you were taken this morning, to enable decision makers faced with a claim from a person in the O'Donnell category to make a decision about whether they're eligible. We've seen that guidance, and my point is this, my lord: it is common ground that no evidence has been advanced by the Secretary of State in this case to suggest that that guidance has been difficult to apply in practice or has caused problems in identifying the correct class of eligible applicants. And that, of course, is relevant both to status and to justification.
Yeah. Well, that's a good point on which to finish. My faint hope obviously disappeared almost as soon as we started. I hope we won't be going all morning, but we do. But you certainly can't go beyond 1 o'clock tomorrow. So you can't, the case can't, and that will be time for reply. Okay. Thank you very much indeed.
My lord, can I just ask what time we're starting tomorrow?
At 10:30.
10:30.
Yes.
I'm going to need mine.
Yeah.
But I'm going to do some trimming tonight because there's some points you can cover.
Okay.
I'll trim as much as I can, but I have to obviously address everything that they
No, I mean,